The lawyer's name was Aldridge. I noticed him before the hearing started, the way I noticed most things in unfamiliar rooms, which is to say carefully and without appearing to. He was perhaps 55, silver-haired in the particular way that certain men cultivate silver hair, because they have learned it does something useful for them in professional settings, and he carried himself with the specific confidence of someone who had walked into rooms like this one several thousand times and had learned, across all those thousands of times, that confidence was itself a form of argument. He had been watching me since I came through the door. Not the direct watching of someone who is staring at you, but the peripheral kind, the occasional glance that communicates awareness without acknowledging it, the professional assessment of a man who has been trained to evaluate adversaries and who is completing his evaluation now while pretending to review his notes. I had set my folder on the table reserved for parties appearing without counsel, which in this particular county court was a smaller table positioned slightly to the side of the main defense position, the physical arrangement of the room communicating, before anyone had said a word, the relative weight the system expected to attach to represented and unrepresented parties. The folder was thin. I had brought what I needed and nothing additional. Aldridge had a stack of documents 2 inches thick. My brother Jeffrey sat beside him in a blue suit that was better than any suit Jeffrey had worn before he hired Aldridge, which told me something about the direction of Jeffrey's thinking over the past several months, about what he believed the performance of this hearing required. Jeffrey and I had not spoken directly since the reading of our mother's will 4 months earlier. That day, in the offices of Harmon and Associates, the estate attorney who had handled our mother's affairs for a decade, Jeffrey had sat across the mahogany conference table with an expression that I had spent my entire childhood learning to read, the expression of someone who believes he is about to receive something he considers rightfully his and is waiting, with barely contained impatience, for the formality of the occasion, to finish confirming this. The will had not confirmed it. Our mother, Eleanor Weston, had left her estate substantially to me. The house in Carrington, the investment accounts she had built carefully across 30 years, the contents of the house, and a modest sum that she had specifically designated, in language the attorney read with the neutral precision of someone who understood that the language would land with force regardless of the tone in which it was delivered, as recognition of the sacrifice and service that most of the world has never fully seen. Jeffrey had stood before the attorney finished reading. I had sat very still in the way I always sat very still when I was absorbing something significant and had watched my brother stand and had understood, in the way that you understand things when you have been watching someone for 40 years, that whatever came next was going to be contested. Whatever came next had been contested. 4 months of letters from Aldridge. 4 months of procedural maneuvers. And now this hearing, which Aldridge had initiated on the grounds of undue influence, diminished capacity, and what his filings described as a pattern of deliberate isolation that had allowed me to shape our mother's decisions in the final years of her life toward outcomes that would not have emerged from a genuinely independent choice. I had read his filings carefully. Then I had come to the courthouse alone. The hearing was scheduled for 9 in the morning, which meant I had arrived at 8:30, which was not a choice exactly, but simply the result of being someone who had spent 20 years in an institution where arriving at the scheduled time was defined as late. I had been standing in the hallway outside Courtroom 4 when Aldridge came through the main entrance with Jeffrey and a paralegal carrying additional files. Aldridge had assessed me immediately, the professional instinct operating before he could prevent it, and then he had looked away with the particular efficiency of someone who has made a classification and moved on to other considerations. I had watched Jeffrey register my presence. Something in his face had shifted, not dramatically. Jeffrey did not do dramatic in public, but the specific micro-tension of a man who had been expecting a thing and has now confirmed that the thing is present and must be managed. He had not spoken to me. I had not spoken to him. The courtroom had opened at 8:55. We had entered in the sequence that the morning's cue determined, and I had taken my place at the smaller table with my thin folder, and Aldridge had settled in beside Jeffrey at the main table with his 2-inch stack and his silver hair and his specific calibration of professional confidence. The judge had not yet entered. Aldridge reviewed his documents with the focused attention of a man who is not actually reviewing his documents, but is performing the review of documents in the way that sends a particular signal to the room. He glanced at me once, briefly, with the particular quality of a glance that is meant to communicate something without its content being provable. I looked at him steadily. He looked back at his documents. "The bailiff," announced the court. Judge Nathaniel Okafor entered. I need to tell you who I was at that table because nothing that follows makes sense without it. My name is Diana Weston. I had grown up in the same house in Carrington, Ohio, that our mother had left to me in her will, a blue-gray colonial on a street of similar houses in a neighborhood that was solidly middle class in its bones, even if individual fortunes within it had diverged considerably over the years. Jeffrey was 4 years older than me. He had been, across the years of our shared childhood, the kind of older sibling who occupied his position in the family with the comfortable authority of someone who has never had reason to question whether that position is secured. I had enlisted in the Army at 18, as I have told people when asked, though telling people when asked had been a rarer event than it might seem, because people who understood the specific trajectory of where my enlistment had eventually led did not often appear. In the contexts where my background came up in ordinary conversation, and people who did not understand that trajectory received, in my general answer of I was in the Army, an impression considerably more modest than what the 20 years had actually produced. 20 years. The specific arc of those years was something I am able to describe, in the general outline that I have been permitted to share, as beginning in conventional infantry support and moving, over the first 8 years, through a series of analytical and operational roles that had produced, by the time I was 26, a recognition within the institution that I possessed a specific combination of capacities that the institution found valuable. What those capacities were, and how they had been deployed across the 12 years that followed, is something I am genuinely not able to characterize in the detail that would make the characterization fully accurate. What I can tell you is that the roles I held across those 12 years had placed me in proximity to decisions and situations whose significance was not theoretical, and that the specific work I had done in those roles had been recognized within the appropriate channels, with the particular kind of recognition that does not appear in public records, and that is therefore, for most practical purposes, invisible to anyone who has not been inside those channels. I had retired 13 months before the hearing. The retirement had been motivated partly by the specific timing of my mother's declining health, which I had become aware of approximately 18 months before the actual diagnosis, the particular awareness of someone who has been paying careful attention to a person for their entire life and who recognizes when something is changing even before the medical framework has named the change. I had returned to Carrington. I had spent 14 months there, living in my mother's house, managing her care, attending appointments, navigating the specific landscape of someone whose health requires sustained management and whose life becomes, gradually and then rapidly, more circumscribed than it was. Jeffrey had visited twice. Once for Christmas, once when the diagnosis was confirmed. Both times with the particular manner of someone who is performing familial duty while existing primarily elsewhere in their mind. I had not made anything of this to my mother. My mother had made nothing of it to me. We had both understood, across the 14 months, what was happening and what it was not happening, and we had chosen, as two people who understood each other well enough to choose, to inhabit the time we had with the full attention it deserved rather than spending any portion of it in the grievance it might also have justified. The will had been her words, not mine. She had written it with the attorney 3 years before her decline began, had updated it once when the diagnosis came, had not changed it across the 14 months of my presence in the house. I had not known its specific contents until the day of the reading, because my mother had not believed that children should know the contents of a parent's will before the parent died, as this created dynamics she found distasteful. She had been right about many things. She had been right about this too. Judge Okafor was 63 years old. He had been on the bench in this county for 11 years, having come to it from a career in civil litigation that had apparently covered, across its span, a reasonably diverse range of disputes. He had a face that communicated, upon first encounter, the particular quality of experienced judicial attention that serious judges develop, the capacity to listen without showing where the listening is going, to absorb without revealing the direction in which the absorption is moving. He settled into his chair. The bailiff confirmed the case number. Aldridge confirmed his appearance for the petitioner. I confirmed my appearance for the respondent, in the specific language that the form required, noting that I was appearing without counsel. Aldridge allowed a barely perceptible pause after this confirmation. The pause was itself a professional instrument, a small piece of theater designed to communicate to the room, and particularly to the judge, that the respondent's decision to appear without counsel was itself evidence of something, a lack of resources, perhaps, or a naivete about what the proceedings would require, or some other condition that distinguished the respondent from the petitioner in ways relevant to the court's assessment. Before we begin, Judge Okafor said, I want to confirm that the respondent has had an opportunity to review the petition and understands the nature of the claims being made. I have, Your Honor, I said. And you've chosen to appear without counsel? I have, Your Honor. He looked at me briefly, the particular look of a judge confirming that the person in front of him understands what they are doing, and then he returned his attention to the materials before him. He had received the case files in advance, as was standard. He appeared to have reviewed them, also standard. He had the petition, he had Aldridge's extensive supporting documentation, and he had the thin respondent's brief that I had submitted 3 weeks earlier. The thin brief was not thin because I had not known what to put in it. It was thin because what I had put in it was specific and sufficient and did not require the 2 inches of supporting material that Aldridge had assembled, because what I had put in it was not an argument about facts, but a set of documents that spoke for themselves in the way that certain documents speak for themselves when the right person reads them. Judge Okafor had apparently not yet read the specific document I was thinking of. It was near the back of what I had submitted. In the sequence, I had placed it deliberately, and the briefs were extensive enough on the petition side that I had calculated the judge's initial review had likely covered the petition's materials more thoroughly than the respondent's. Aldridge stood to deliver his opening. It was a polished opening. 20 years of courtroom experience had given him the specific fluency of someone who understood how to build a narrative from individual pieces of evidence, how to arrange the pieces so that each one added weight to the impression the previous one had created, how to speak in the register that communicated to a judge that the speaker was serious and the case was serious, and the outcome the speaker was advocating for was the outcome that seriousness required. He spoke for 18 minutes. He described Jeffrey and Eleanor Weston's relationship with the particular warmth of an attorney who has been briefed on what warmth to display and who has rendered it convincingly. He described my return to Carrington and my 14 months in the house with our mother with the particular inflection of someone casting a set of facts in their least flattering light without technically misrepresenting any of them. He described the will and its contents and the departure they represented from what he characterized as Eleanor Weston's long-standing wishes and intentions, citing several documents he had obtained that he described as evidence of those wishes. He built the case carefully, and he built it well, and when he sat down the room held the particular quality of a room in which a narrative has been established, and the next task is to respond to it. Aldridge looked at me with the particular expression of an attorney who has just delivered a strong opening and is waiting to see what the unrepresented respondent believes she has. He said, I'm not sure the respondent appreciates the full complexity of what she's facing today. It was not directed at me exactly. It was directed at the room, the kind of statement that sounds like observation but functions as argument, a comment on the respondent's preparedness that was also a communication about the relative sophistication of the two parties. Judge Okafor looked at him briefly, and then looked at me. Ms. Weston, he said, would you like to respond? I would, I said. I stood. I opened my thin folder. And I began. I did not deliver an opening argument in the conventional sense of the term. What I delivered was a series of specific, direct responses to the specific claims Aldridge had made, organized in the order in which he had made them, each response supported by a specific document or a specific fact that could be verified through channels available to the court. I spoke for 11 minutes. I was precise. I did not use more words than the precision required. When I sat down, Aldridge had the particular expression of someone who has just listened to a response that was better than they anticipated and is recalibrating how to proceed. He recovered quickly. He was good at recovering quickly. Your Honor, he said, the respondent's presentation raises several points that we'd like to address directly. Specifically regarding the claim that her presence in the house during the final months represented independent caregiving rather than a calculated strategy of. Mr. Aldridge, Judge Okafor said, I'd like to review the submitted materials before we go further. Could you give me a few minutes? Aldridge sat down. The room held the particular quality of rooms holding while a judge reads, the temporary suspension of the usual dynamics, while the authority in the room does the thing that renders the other dynamics secondary. Judge Okafor read. He read the petition materials he had apparently already reviewed. He read Aldridge's supporting documentation, spending varying amounts of time on different sections. Then he reached the respondent's submission. He read slowly. He turned one page, then another. He reached what I knew was the third section of my submission, which contained the documentation that I had placed there deliberately, in the sequence that would make it most legible in the context of what had preceded it.
He stopped.
He read the section again. Then he turned to what was behind it, the specific document that was the last thing in the submission, the one I had placed last because it needed to be received with all the preceding context in place. The courtroom was quiet. Aldridge was watching the judge with the particular professional attention of someone trying to read, from the judge's expression and posture, the direction in which the reading was moving. Jeffrey was watching something on the table in front of him, with the careful non-expression of someone who has learned to not display reaction in courtrooms while his attorney was doing work. I was looking at the window on the far wall. There was a courtyard outside it, trees bare in the November morning, a bench that no one was sitting on. The light was the particular gray of a Midwestern November morning that has committed to grayness and will not relent. Then Judge Okafor stood up. In my experience of courtrooms, which was limited before this hearing but not entirely absent, judges do not stand while reading. The standing up of a judge, in the middle of a preliminary review of submitted materials, is not something the procedural rhythm of a hearing typically includes, and its occurrence produces, in the room where it occurs, a specific quality of attention that is different from all the attention that preceded it. Every person in courtroom 4 on that November morning became, in the moment that Judge Okafor stood, completely still. He was looking at the document in his hand. He turned it once, as though confirming that it was what it appeared to be, and then he looked up.
He looked at me.
He said, "Ms. Weston, could you approach the bench?" I stood. I walked to the bench. I stood before Judge Nathaniel Okafor in the small courtroom in Carrington, Ohio, on a November morning, holding nothing in my hands because everything I needed was already in the submission he was holding. He spoke quietly enough that what he said was between us rather than the room. "Is this current?" he asked. "As of 16 months ago," I said. "When I retired." He looked at the document again. Then at me. "I want to confirm," he said, "that I understand what I'm reading." "I can answer questions," I said, "within the limits of what I'm permitted to discuss in this setting." He asked a specific question. I answered it with the minimum specificity required to confirm what he needed to confirm. He asked another. I answered that one too. Then he was quiet for a moment, still holding the document, still standing, and the room continued to hold the quality of rooms where something is happening that most of the people in them do not yet fully understand. He said, "I'll need a moment to review the full implications of this for the matters before me." "Of course, Your Honor," I said. I returned to my table. Aldridge spoke quietly to Jeffrey for perhaps 30 seconds after I sat down, the lateral communication of an attorney and a client who are trying to understand what has just happened without revealing that they do not understand it. Aldridge had not been able to see the specific document that had produced the judge's response. He had seen the physical object, a document in a folder, but not its content. He had registered the judge's reaction without being able to interpret it because the content that had produced the reaction was not something his preparation had anticipated. This was not accidental. I had submitted the document in the sequence I submitted it because I had understood, from the moment I decided to handle this hearing without representation, that the document's value depended on the context in which it arrived. If it arrived first, before the other materials had been read and considered, it would land without the framework that gave it its full weight. If it arrived where I had placed it, after the court had read the petition, and after it had read the respondent's substantive responses to that petition, it would arrive in a context that rendered its significance immediately clear. I had handled a small number of cases in my professional career that required this kind of sequencing, the arrangement of information in the order that would produce the most accurate comprehension in the mind of the person receiving it. The mechanics were the same regardless of the setting. What the document contained, I am going to describe in the general terms that I am permitted to use. It was a form of certification from a federal agency whose name I am also not going to specify, confirming that the individual named within it had served in a capacity that I will characterize as significant and that had involved, across its duration, the specific combination of analytical and operational responsibilities that I have already described in the general terms available to me. The certification was the kind of document that exists to provide, in contexts where the underlying service cannot be described, a form of evidence of that service that conveys its general nature and significance without revealing the specifics that remain protected. It also contained, in the specific language of such certifications, a characterization of the nature of the work that was remarkable in its directness for a document produced by the institution that produced it, a characterization that I will not reproduce here, but that I will describe as leaving very little ambiguity about the level at which the named individual had operated and the significance of the contributions she had made. I had included it in my submission because Aldridge's petition had characterized me as someone whose relationship with my mother was suspicious precisely because of its sustained intimacy, the theory being that my extended presence in the house had been an effort to isolate Eleanor Weston and influence her decisions. This theory rested on an implicit assumption about who I was, an assumption derived from the same kind of limited visible information that had led Patterson to his conclusions in the briefing room, the assumption that what could be seen was all there was to see, and that what could be seen was insufficient to explain why a woman like me had returned to Carrington to care for her mother. The document provided the context that Aldridge's theory had failed to account for. It confirmed, in language that carried the weight of its institutional source, that the woman who had returned to Carrington was not who Aldridge's narrative had portrayed her as being. Judge Okafor returned his attention to the room after approximately 4 minutes of review. He sat down, which produced in the room the specific exhale of returning to normal conditions after the suspension of normal conditions. He looked at Aldridge. "Mr. Aldridge," he said, "I've completed my initial review of the submitted materials. Before we continue with the substantive hearing, I have a question for you." "Of course, Your Honor," Aldridge said, with the professional fluency of someone who has spent decades being asked questions by judges. The petitioner's case rests substantially on the characterization of the respondent's return to Carrington as motivated by an interest in influencing the decedent's estate planning rather than by genuine caregiving obligations. Is that an accurate summary? "That's one element of the petition," Aldridge said carefully. "Yes. And this characterization assumes that the respondent's reasons for returning, beyond the stated caregiving function, were connected to the estate's disposition. The petition argues that the combination of extended presence, isolation from other family members, and the departure of the will from what we characterize as the decedent's historical intentions constitutes a pattern consistent with undue influence." "I understand the theory," Judge Okafor said. "What I'm asking is whether the petition accounts for the possibility that the respondent returned to Carrington for reasons that had nothing to do with the estate and everything to do with the respondent's understanding of her obligation to her mother." Aldridge was quiet for a moment, the specific quiet of someone identifying a question as more complex than it initially appeared. "We would argue," he said, "that the intent is relevant regardless of the stated motivation." "The intent may be," Judge Okafor said, "but the characterization of who the respondent is, and what might have motivated her return, appears to be operating on an incomplete picture." He looked toward me briefly, then back at Aldridge. "I'm going to allow the petitioner to continue, but I want to be direct with you about something. The respondent's submission contains documentation that I had not anticipated encountering in a hearing of this nature, and that documentation substantially complicates the theory of motivation that the petition relies upon. I would encourage you to consider, as we proceed, whether the evidentiary foundation for the undue influence claim is as solid as you may have believed it to be when the petition was filed." Aldridge said nothing for a moment. Jeffrey, beside him, appeared to be calculating something. Then Aldridge said, "Your Honor, could you characterize the documentation you're referring to so that we might?" "I can tell you that it's from a federal source," Judge Okafor said, "and that it pertains to the respondent's professional history in ways that I think you'll find relevant to the picture of her motivations that you've been presenting to this court." Another silence. Then Aldridge said, with the specific careful modulation of someone choosing his next words very deliberately, "We would request the opportunity to review the documentation before proceeding." You're entitled to it, the judge said. It was submitted as part of the respondent's filing, which your firm received 3 weeks ago. I watched Aldridge's expression perform a rapid series of adjustments as he processed the fact that the document had been in his possession for 3 weeks and had apparently not received the kind of attention that would have allowed him to understand its significance before this morning. He reached for his copy of the respondent's submission. He found the document. He read it. The room was very quiet while he read. When he looked up, he had the expression of a man who has just discovered that the ground he has been standing on is not the ground he believed it to be, and who is now conducting a rapid assessment of how different the actual ground is from the imagined ground. He looked at Jeffrey, then at the document, then at the judge. He said, "Your Honor, I'd like to request a brief recess to confer with my client." The recess lasted 20 minutes. I sat at my table and looked at the bare trees through the courtroom window and did not think about what was happening in the hallway, because thinking about what was happening in the hallway would not change what was happening, and composure in the absence of relevant action was simply the discipline of waiting productively. I thought instead about my mother, about the specific quality of the 14 months we had spent in the house in Carrington, which had been, by any external measure, demanding and sometimes painful in the particular ways that caring for a dying parent is demanding and painful, and which had been, at the same time, something that I valued in a way that I had not anticipated valuing when I first returned. My mother and I had been close in the way that a mother and a daughter who respect each other are close, which is different from the closeness of dependence or the closeness of uncomplicated warmth, though both of those things were also present. We had been close in the way of people who have spent decades understanding each other with increasing accuracy and who find, in the final period of the relationship, that the understanding has reached a depth that makes almost any shared activity, however ordinary, feel significant. We had cooked together when she was able to. We had watched films she had been meaning to watch for years. We had talked, in the way that people who understand each other can talk, about things that were real and things that were difficult and things that neither of us had ever found quite the right occasion to say before this period gave us the occasion. She had asked me, one evening in the spring of the previous year, whether I had any regrets about the career. I had thought about this honestly before answering. No, I had said, but I have things I grieve about it, which is different. She had waited. I grieve, I had said, that most of what it required cannot be described to the people who matter most to me. That the significance of it will never be legible to you, or to Jeffrey, or to most of the people who know me. That the years are real, and the work is real, and the realness of both of them exists in a space most people I love will never have access to. She had been quiet for a moment. Then she had said, I know. I have known for 20 years that you were carrying something I didn't have the words for. And I want you to know that the not having words didn't mean the not knowing. I have known, without the words, that what you built was extraordinary. And I am very proud of it. It was the most direct conversation we had ever had about my career. We had not had another one quite like it. The will, when I read it on the day of the reading, had felt like the continuation of that conversation in the only language available to her after she was gone. Aldridge came back into the courtroom with Jeffrey beside him, both of them having the quality of people who have had a conversation in a hallway that has produced a reorientation of the positions they held when they entered the hallway. Aldridge sat down, arranged his materials, and said, Your Honor, I'd like to address the court before we proceed. Go ahead, the judge said. Having reviewed the documentation in the respondent's submission more carefully, Aldridge said, and having consulted with my client during the recess, I want to advise the court that we are reconsidering the basis for the petition as filed. He paused. Specifically, the argument regarding the respondent's motivations for returning to Carrington was built on a characterization of the respondent that I now understand to be materially incomplete. The room held a particular quality of attention. We are not prepared to withdraw the petition at this time, Aldridge continued, with the professional precision of someone who is managing a significant development in real time and doing it as skillfully as the situation allows. But we would like to request a continuance to allow us to reassess the evidentiary foundation of the claims we have made. Judge Okafor looked at him for a moment. Then he looked at me. Ms. Weston, do you have any objection to a continuance? I had anticipated this possibility. I had thought about my response in advance. I don't object to a continuance, Your Honor, I said. However, I'd like to note for the record that the documentation in question has been available to the petitioner's counsel for 3 weeks through the normal discovery process, and that the petition's characterization of my motivations was made on the basis of a choice not to review that documentation with sufficient care. The statement landed in the room with the specific weight of a statement that is accurate and whose accuracy is now beyond contest. Aldridge did not respond to it directly. Judge Okafor said, "I'll grant the continuance. But I also want to be direct with both parties. The documentation the respondent has submitted raises questions about the fundamental premise of the petition that I think warrant serious reconsideration before we invest additional court time in proceedings that may not have the evidentiary foundation they appeared to have when they were initiated." He looked at Aldridge. "Counsel, I'd encourage you to complete that reconsideration thoroughly before the next scheduled date." "Understood, Your Honor," Aldridge said. The hearing concluded. Jeffrey caught up with me in the parking lot. Not Aldridge. Jeffrey himself, which told me something about the specific quality of the recess conversation they had had in the hallway, about the fact that whatever had shifted in the 20 minutes had shifted at the client level rather than just the attorney level. He was wearing the good suit and the expression of someone who has spent the morning having their understanding of a situation revised significantly and is still in the early stages of integrating the revision. "Diana," he said. I turned. He looked at me for a moment. The November wind moved through the parking lot with the particular efficiency of November wind in Ohio, which does not waste time. "I didn't know," he said. "What you did. What it was. I knew you were in the Army. I didn't know it was whatever that document says it is." I said nothing. "Why didn't you tell me?" he said. I thought about how to answer this honestly. "Because most of it I couldn't tell you," I said. "And the parts one could tell you, I did tell you. I told you I was in the Army. I told you I had spent 20 years in a career that mattered. You never asked what it actually was." He looked at the ground briefly, then back at me. "Mom knew," he said. "It was not a question. She knew what she could understand without the details," I said. "Which was the shape of it. That it was real and significant. She didn't need the specifics to understand that. She wrote the will because of it," he said. "She wrote the will because of who I am to her," I said. "Which includes the career, yes. But it's not only the career." He was quiet. "I was angry," he said finally, "when the will was read. I was angry because I felt like the will assumed something about me that wasn't fair. That I hadn't been present, hadn't cared, hadn't been the kind of son she deserved." "You weren't present, Jeffrey. The words were not cruel. They were simply accurate, and he did not argue with them." "I know," he said. "I know I wasn't. I was managing things. My own life. My own," he stopped. "I told myself she was okay. That she had people around her. That she didn't need me specifically." "She needed you," I said. "Not instead of me. In addition to me. And you decided your life was too complicated to manage that." He absorbed this. "Is there a path," he said, "where this doesn't end up in court again?" I thought about my mother. About the evenings in the house. About the conversation in the spring, and the things she had said about knowing without the words. "Withdraw the petition," I said. "Not because you're going to lose, though I believe you will, but because continuing to contest our mother's wishes is not who you want to be. It's not who she needed you to be when she was alive, and it's not who she would want you to be now." He looked at the ground again. "Aldridge is going to tell me I have options," he said. "Aldridge is going to tell you what you're paying him to tell you," I said. "I'm telling you what's true." He was quiet for a long time. Then he said, "I'll talk to him." It was not an answer, but it was something, the specific something of a person who has had his framework disrupted in ways he has not yet finished processing, and who is indicating that the processing will continue. I nodded. Then I walked to my car. The petition was withdrawn 11 days later. Aldridge filed the withdrawal without further communication to me directly. Jeffrey did not call. I did not call Jeffrey. I went back to the house in Carrington. I am in the house in Carrington now, living the particular life of someone who has returned to the place they came from after a long time somewhere else and who is learning, in the specific ordinariness of returning, what it means to inhabit a place rather than simply occupy it. The house is my mother's house, which means it is full of the particular evidence of a life lived fully in specific, ordinary ways, the kitchen organized according to a logic that took me 2 weeks to fully understand, the garden that requires more attention than I had anticipated, the neighbors who have lived on the street for decades and who knew my mother and who know me only as Eleanor's daughter, who came home and then stayed. I have not told them much about the years between. There is no adequate occasion to tell them, and the years resist the casual summary that social occasions require, and I have learned, across a career that trained me in the management of information that resists casual summary, to be comfortable with the gap between what I can share and what is actually true. My mother would have appreciated the comfort. She was someone who understood that not everything could be said, and that not saying everything was not the same as not being understood. I walk the neighborhood in the early mornings, the habit of 20 years that my body still expects, and I think about the courtroom and the judge and the document, and what it means that a piece of paper I had carried for 2 years without occasion to produce it had, on a November morning in Ohio, stood up when everything else in the room needed to be corrected. I think about Jeffrey and about what the 11 days of deliberation looked like from the inside of whatever he was processing, and about whether the petition's withdrawal represents a beginning or simply an ending, and about the specific difference between those two things in the life of a family that has been what this family has been. I think about my mother's words in the spring evening. I have known, without the words, that what you built was extraordinary. That is the thing I return to most often, in the particular quiet of the house in the early mornings and the particular quiet of the house in the evenings. Not the courtroom, not the judge standing, not Aldridge's face when he read the document, but my mother's voice, saying she had known without the words, saying that the not having words didn't mean the not knowing. She had seen me, without the document, without the federal certification, without any of the institutional language that had caused a judge in a small Ohio courtroom to stand up while reviewing a submitted filing. She had simply looked at her daughter and seen her. That was worth more than any courtroom. That was the whole inheritance, really. Everything else was just the form it took. I want to say something before I finish about what it means to build a life that most of the world cannot see. I spent 20 years in work whose significance exists in a space most people will never access, whose outcomes have consequences that most people will never trace to their source, whose costs and difficulties and moments of genuine consequence have no adequate language in the conversations most people have with each other. This is not unique to the specific kind of work I did. There are 1,000 forms of significant invisible labor, 1,000 kinds of contribution that lack adequate language in the rooms where recognition is distributed, 1,000 lives built solidly in the spaces where the frameworks used to measure worth simply do not apply. I had a document. The document mattered on a November morning in a specific and significant way. I am grateful for the document and for what it was able to do. But I want to be honest that the document was not the substance of what I had built. It was the evidence of the substance, the institutional trace of work whose actual significance existed in a different register entirely, in the specific rooms where the specific decisions were made, and the specific outcomes were produced, and the specific costs were paid. The substance was the work. The work was always the substance. And my mother had known this without the document, without the certification, without any of the institutional language that gave a judge reason to stand. She had simply looked at her daughter and understood. That is the thing I wish I could tell everyone who is building something significant in the space where the frameworks do not apply, in the room where the document does not exist yet, or where the document exists but will never be shown, or where the contribution is real and matters, and simply has no available form of evidence that courtrooms accept. The people who love you and who look carefully can know without the words. And the people who look with Crawford's kind of attention, or the judge's kind of attention, or simply the kind of attention that allows a person to register what is actually there rather than what is expected, those people will find their way to the truth eventually. Even without the document. Even without the certification. Even without anything but the specific, careful quality of actually seeing you. Thank you for spending this time with me. If this story found you where it needed to find you, I would love to know where you are watching from and what part of it you will carry forward. Stay with us.
There are more stories to tell.
I want to tell you more about the specific relationship between Jeffrey and me, because the courtroom was not the beginning of the story between us, and the withdrawal of the petition was not its end, and the middle deserves more than I have given it. We had been, for most of our childhood, the kind of siblings who were close in the way that siblings who do not have many other options are close, the proximity of shared space and shared parents, and the shared experience of a family life that was, on balance, good, genuinely and straightforwardly good, without the dramatic dysfunction that makes for compelling stories, but also without the extraordinary warmth that makes for easy ones. Jeffrey had been the older one, the first one. The one who established the template against which I was subsequently measured, which was a template organized around a particular kind of visible competence, the kind that can be pointed to in ordinary social contexts, grades and athletic achievements, and the specific social ease of someone who learned early that other people's liking was something he could cultivate and maintain with the right kind of effort. I had been the other kind of competent, the kind that does not announce itself easily. The kind that exists in the gap between what can be shown and what is actually there, visible only to people who have developed the right kind of attention for seeing it. My mother had that attention. She had had it, I believed, since I was perhaps 6 or 7 years old, that specific moment in a child's development when the characteristic that will define the adult begins to be legible to someone who is watching carefully enough. She had watched carefully enough. And she had held what she saw across 30-some years of the relationship we had built, adding to it incrementally as the years added evidence, never quite able to put words to the full shape of it, but also never quite losing the shape itself. Jeffrey had not watched carefully, not because he was incapable of careful watching, but because the framework within which he understood people had been organized around the kind of competence that can be seen and pointed to and discussed at dinner tables, and I had never produced that kind of competence in the context he was watching. In his first years at the company where he worked, he had told people he had a sister who was in the army. Later, when his professional world had expanded to include people whose own military connections or adjacent professional world would have made a more specific characterization possible, he had still said sister in the army. The more specific characterization had not been available to him because he had not asked the questions that would have produced it. I had not offered it, for reasons I have already described. What I want to say about Jeffrey is something that is harder than what I have already said, because what I have already said positions him, largely, as the person in the wrong, and while that positioning is accurate in its specific content, it is incomplete in its full accounting. Jeffrey had grown up in the same family I grew up in. He had received from our parents the same fundamental love and the same fundamental care. He had developed, within the family system, a particular strategy for navigating life that had worked well enough within that system to become, over time, his default mode of operating in the world. That mode involved a specific relationship with visibility. Jeffrey lived in the visible layer of things. He was good at the visible layer. The visible layer rewarded him. And the reward of the visible layer had, over time, made the invisible layer progressively less interesting and less accessible to him, not through malice but through simple reinforcement, the way that any organism develops preference for the environment that has consistently produced positive outcomes. I had developed, in the same family system, the opposite relationship with visibility. I had become proficient, across 20 years of professional training and natural inclination, at the invisible layer. The invisible layer was where my actual capacities resided. The invisible layer was where the work that mattered happened. The invisible layer had been the right layer for me, and I had inhabited it with genuine conviction. The gap between us was not the gap between a bad sibling and a good sibling. It was the gap between two people who had developed different relationships with visibility and who had failed, across 40 years, to find adequate language for the relationship across that gap. The courtroom had provided, in the specific form of a federal document and a judge who stood to read it, a moment of translation across the gap. Whether the translation would persist, whether it would produce something more than the narrow outcome of a withdrawn petition, was not yet clear to me in the weeks after the November hearing. I did not know at that point whether the gap between Jeffrey and me was something that could close, or whether it was simply something that the two of us would manage across the remaining years of our lives with the particular accommodation of siblings who understand they are different and have made a working peace with the difference. What I knew was that our mother had not believed the gap was permanent. She had written a will that was, among other things, an act of faith, a bet that the translation would eventually become possible, that the form the inheritance took would eventually produce a version of Jeffrey capable of looking across the gap and seeing what was on the other side. I was willing to wait to find out if she had been right. She had been right about most things. The phone call came 6 weeks after the petition was withdrawn. It was Jeffrey. He had not called in the months since the reading of the will, which made the call itself the most significant piece of information it contained before he said a single word. I answered. "I want to come to Carrington," he said. "To the house. Not to contest anything. Just to come." I thought about this. "When?" I said. "Whenever you're willing to have me." I looked around the kitchen, which was organized in my mother's logic, which I had now fully internalized, and which was full of the particular ordinary evidence of a life being lived in a specific place with genuine attention to what the place required. "December," I said. "Come for part of Christmas. We can figure out what that means when you get here." He was quiet for a moment. "Thank you," he said. "Don't thank me yet," I said. "We're going to have conversations that are going to be uncomfortable." "I know," he said. "I need you to actually know that," I said. Not in the way of saying it, and then being surprised when it's true. I mean it specifically. There are things I can tell you now that I couldn't tell you before. Not all of them, but more. And there are things we need to say about the 14 months, and about what you were not there for. I need you to be willing to hear all of it. "I'm willing," he said. I had no way of knowing, at that point, whether he was right about his own willingness. Willingness declared in advance of the specific difficulty that tests it is not the same as willingness exercised in the moment of that difficulty. But he had called, and calling had been, for Jeffrey, a form of willingness I had not previously observed from him, and I was willing to receive it as what it appeared to be. "December," I said again. "I'll let you know the dates." "Okay," he said. After we hung up, I stood in my mother's kitchen for a long time, looking at the window above the sink, through which the December light was coming in the particular gray way of December light in Ohio, and I thought about what the following weeks might hold, and what they might not. I thought about my mother saying she had known without the words. I thought about whether knowing without the words could be taught, transmitted, passed across the gap that had existed between me and Jeffrey for 40 years. I did not know. But I thought about the federal document and the judge standing and the specific, quiet way that a single piece of evidence, placed in the right context and received by the right person with the right kind of attention, had shifted the entire structure of a morning that had been organized against me. I thought about the possibility that Jeffrey, coming to Carrington in December, sitting in our mother's kitchen, hearing what I was able to tell him and sitting with what I was not, might be for him the equivalent of that morning, the specific moment in which the framework he had been working from encountered enough new information to begin, slowly and imperfectly, to revise. It might not happen. The framework might prove too durable. The gap might prove too wide. But our mother had believed it was possible. She had structured her final act of love with the bet that it was possible. I was willing to take the same bet. I was, after all, her daughter. And she had never been wrong about things like this. Thank you for staying with me all the way to the end of the story. If you are someone who has been carrying something that the available frameworks cannot quite account for, whether in a courtroom or a family or any other room that has measured you with the wrong ruler, I hope something in this story helped. The wrong ruler cannot measure the right thing. And eventually in the right room, with the right document or the right word or simply the right pair of eyes, the actual thing becomes visible. Stay with us. There are more stories to tell.